India's application, dated the 8th of May 2017, instituting proceedings against the Islamic Republic of Pakistan, concerns alleged violations of the Vienna Convention on Consular Relations, I quote, "in the matter of the detention and trial of an Indian national," end of quote, "sentenced to death in Pakistan, Mr. Kulbhushan Jadhav. To found the jurisdiction of the court, India relies on Article 36, paragraph 1 of the Statute of the Court and on Article 1 of the optional protocol concerning the compulsory settlement of disputes which accompanies the Vienna Convention. I shall now ask the Registrar to read out the decision requested of the Court as formulated in the application of India.
In the circumstances, India seeks the following reliefs. 1. A relief by way of immediate suspension of the sentence of death awarded to the accused. 2. A relief by way of restitution in interregnum by declaring that the sentence of the military court arrived at, in brazen defiance of the Vienna Convention rights and Article 36, particularly Article 36, paragraph 1b, and in defiance of elementary human rights of an accused, which are also to be given effect as mandated under Article 14 of the 1966 International Covenant on Civil and Political Rights, is violative of international law and the provisions of the Vienna Convention. And 3, restraining Pakistan from giving effect to the sentence awarded by the military court and directing to take steps to annul the decision of the military court as may be available to it under the law in Pakistan. 4, if Pakistan is unable to annul the decision, then this court to declare the decision illegal, being violative of international law and treaty rights, and restrain Pakistan from acting in violation of the Vienna Convention and international law by giving effect to the sentence or the conviction in any manner and directing it to release the convicted Indian national forthwith.
On the same day as the filing of the application, India submitted a request for the indication of provisional measures referring to Article 41 of the Statute of the Court and to Article 73, 74 and 75 of the Rules of Court. In that request, India states that the alleged violation of the Vienna Convention by Pakistan has prevented India from exercising its rights under the Convention and has deprived Mr. Jadhav from the protection accorded under the Convention. The applicant also submits that Mr. Jadhav, I quote, will be subjected to execution unless the court indicates provisional measures directing the government of Pakistan to take all measures necessary to ensure that he is not executed until the court's decision on the merits of the case, end of quote. India points out that Mr. Jadhav's execution would cause irreparable prejudice to the rights, it claims. India further indicates that the protection of its rights is a matter of urgency as, I quote, without the provisional measures requested, Pakistan will execute Mr. Kulbhushan Jadhav, before the court can consider the merits of India's claims, and India will forever be deprived of the opportunity to vindicate its rights. End of quote. I shall now ask the Registrar to read out the passage from the request specifying the provisional measures which the Government of India is asking the Court to indicate.
India respectfully requests that pending final judgment in this case, the Court indicates A. That the Government of the Islamic Republic of Pakistan take all measures necessary to ensure that Mr Kulbhushan Jadhav is not executed. B. That the Government of the Islamic Republic of Pakistan report to the Court the action it has taken in pursuance of subparagraph A, and C. That the Government of the Islamic Republic of Pakistan ensure that no action is taken that might prejudice the rights of the Republic of India or Mr Kulbhushan Jadhav with respect of any decision the Court may render on the merits of the case.
On 8 May 2017, immediately after the filing of the application and request for the indication of provisional measures, the Registrar, in accordance with Article 40, Paragraph 2 of the Statute and Articles 38, Paragraph 4 and 73, Paragraph 2 of the Rules of Court, transmitted certified copies thereof to the Government of the Islamic Republic of Pakistan. He also notified the Secretary General of the United Nations of the filing of these documents by India. By a letter dated the 9th of May 2017, referring to Article 74, Paragraph 4 of the Rules of Court, in my capacity as President of the Court, I called upon the Islamic Republic of Pakistan, I quote, to act in such a way as will enable any court the court may make on the request for indication of provisional measures to have its appropriate effects, end of quote. According to Article 74 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Referring to the, I quote, the extreme gravity and immediacy of the threat, end of quote, India asked the court to render an order on its request without a hearing. The court decided to hold a hearing in order to allow both parties to present their arguments. Given the circumstances, the court decided that the oral proceedings contemplated in Article 74, Paragraph 3 of the Rules of Court should be brief and held on rather short notice on 15th May 2017, today. I note the presence before the court of the agents and counsel of the two parties. The court will hear India, which has submitted the request, this morning until 11:30 a.m. It will hear Pakistan this afternoon from 3 to 4:30 p.m. The hearings on India's request for the indication of provisional measures will be closed at the conclusion of this afternoon's session. For the purposes of these oral arguments, each of the parties will have available to it a full 90-minute sitting. India may, if required, avail itself of a short extension beyond 11:30 a.m. this morning, in view of the time taken up by the opening part of these oral proceedings. The parties are, of course, not required to use the full amount of time allotted to them. Before giving the floor to the agent of the Republic of India, Dr. Deepak Mittal, I wish to draw attention to Practice Direction 11, which states inter alia that parties should, I quote, in their oral pleadings on requests for provisional measures, limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. End of quote. I now call upon Dr. Deepak Mittal, agent of the Republic of India.
Mr. President and honorable members of the court, it is indeed a great honor for me to appear today before this august court on behalf of the Republic of India as India's agent at the oral hearings on India's request for indication of provisional measures in the proceedings instituted by India against the Islamic Republic of Pakistan on 8 May 2017. This case concerns an Indian national, Mr. Kulbhushan Jadhav, who has been awarded death sentence by a military court in Pakistan in egregious violation of the rights of consular access guaranteed by Article 36, Paragraph 1 of the Vienna Convention on Consular Relations 1963. At the outset, I would like to thank the court and the President for the timely decision and action to exercise the powers conferred upon him under Article 74, Paragraph 4 of the Rules of Court and send an urgent communication on 9 May to the Prime Minister of the Islamic Republic of Pakistan, calling upon the government of Pakistan to act in such a way as will enable any order the court may make on India's request for the indication of provisional measures to have its appropriate effects. Mr. President, members of the court, the fact that the hearing is taking place today within 7 days of the institution of proceedings by India is testament to the recognition of the urgency by the court in the case of an innocent Indian national, Mr. Jadhav, who, incarcerated in Pakistan for more than a year on concocted charges, deprived of his rights and protection accorded under the Vienna Convention, being held incommunicado without contact with his family and the home state, is facing imminent execution. All notions of human rights are now considered by the global community as basic to behavior in civilized nations have been thrown to the winds. By this timely action by the President and the court, this institution has provided succor not just to India and to its beleaguered national and his family, but also has given hope to 1.25 billion people of India and hope to the old mother and father of the innocent Indian national that justice would be meted out to their innocent son by this highest seat of justice and a precious life will be saved. Today, accompanied by my colleagues, I appear before the court on behalf of the Republic of India with the hope that the court would indicate provisional measures so that the death sentence which has been awarded to Mr. Jadhav through a farcical trial in a Pakistan military court in violation of the rights guaranteed to Mr. Jadhav and India under Article 36, Paragraph 1 of the Vienna Convention would be set aside and not carried out pending final decision of the court on India's application. I take this opportunity to introduce the members of my delegation. They are Mr. V.D. Sharma, co-agent, Mr. Harish Salve, counsel, Ms. Kajal Bhatt, advisor, Ms. Chetna Rai, junior counsel. I would now present brief facts of the case, which would be further elaborated upon during the hearing. India was informed on 25 March 2016 that an Indian national was allegedly arrested on 3 March 2016. India, on that very day, sought consular access to the said individual. The request did not evoke any response. On 30 March 2016, India sent a reminder reiterating the request for consular access at the earliest. Despite a number of such reminders for consular access sent by India, there has been no response and all these requests fell on deaf ears. Meanwhile, on 23 January 2017, India received from Pakistan a request for assistance in investigation process. Subsequently, on 21 March 2017, almost a year after India's first request for consular access, Pakistan formally communicated to India that consular access to Mr. Jadhav, I quote, shall be considered in the light of Indian side's response to Pakistan's request for assistance in the investigation process, unquote. India responded that consular access would be an essential prerequisite in order to verify the facts and understand the circumstances of Mr. Jadhav's presence in Pakistan. On 10 April 2017, India learned from press reports that Pakistan proceeded to have a military trial against Mr. Jadhav, and he was sentenced to death purportedly on the basis of a confessional statement, and that this sentence was confirmed by the Chief of the Army Staff of Pakistan. Ironically, later in the day, after that sentence has been awarded and confirmed, India received a note verbal from Pakistan reiterating the condition for considering consular access in return for India providing assistance in the investigation process. India responded the same day, highlighting that the offer of conditional grant of consular access after award and confirmation of death sentence reflected the farcical nature of the proceedings and so-called trial by a Pakistan military court against Mr. Jadhav. Despite requests by India, Pakistan has not provided any information or documents, including the charge sheet, proceedings of the court of inquiry, the summary of evidence, the judgment. Request for appointment of a defense lawyer for Mr. Jadhav has also not elicited any response. The mother of Mr. Jadhav, even in the absence of any document, submitted an appeal to the Court of Appeal and a petition to the federal government of Pakistan. This appeal was filed even though it was unable to address any of the issues that may have been put against Mr. Jadhav in the judgment and order of conviction. It was an act of desperation by grieving parents. The parents of Mr. Jadhav applied for visa on 25 April 2017 to travel to Pakistan. There has been no response. The Minister of External Affairs of India has written to the advisor to the Prime Minister of Pakistan on Foreign Affairs on 27 April 2017 for his personal intervention in the matter, but there has been no response. All that we know is what we have seen in the media in Pakistan. Pakistan officials have been reported as having said clearly that Mr. Jadhav would not be provided consular access. Mr. President, members of the court, India believes that a farcical nature of the proceedings and unjust trial by a Pakistan military court in egregious violation of the rights of consular access under the Vienna Convention has led to serious miscarriage of justice. It is clear that Mr. Jadhav has been denied the right to be defended by a legal counsel of his choice. He has not been informed of his right to seek consular access. His conviction and death sentence appears to be based upon quote, unquote, confession taken in captivity without proper legal representation and in absence of consular access sought by India. If we closely follow the reports in the media in Pakistan, we can get the sense that an increasing number of death sentences awarded by military courts in Pakistan have been carried out after 10 April 2017. That's when the death sentence to Mr. Jadhav was confirmed. In fact, over the past 1 month, 18 such executions have been reported through press releases issued by the Inter-Services Public Relations, the military spokesman of Pakistan. In such circumstances, including where there is no response to the requests made through diplomatic channels, there is an immediate threat that death sentence against Mr. Jadhav may be carried out even before India has the opportunity to be heard and the court has a chance to consider the merits of the case, and thus causing irreparable prejudice to the rights of India and Mr. Jadhav. Mr. President and the members of the court, India has invoked the jurisdiction of the court and sought provisional measures. My colleagues will elaborate further on this. I would now request the court to invite Mr. V.D. Sharma, co-agent for the Republic of India, to make his submissions. Thank you.
Merci, monsieur. Avant de donner la parole au co-agent de la République de l'Inde, le docteur Sharma, je demanderai aux plaideurs de bien vouloir ne pas parler trop vite, de manière à permettre aux interprètes de faire leur travail de traduction dans l'autre langue officielle de la Cour. Je les en remercie d'avance. Monsieur le docteur Sharma, co-agent de la République de l'Inde, vous avez la parole.
Mr. President, distinguished members of the court, it's a great honor for me to appear before this court as co-agent of the Republic of India in the case concerning the violation by the Islamic Republic of Pakistan of the Vienna Convention on Consular Relations, 1963. I propose to devote my observations to the key issues which would be addressed in elaboration by my colleague, Mr. Harish Salve, concerning violation by Pakistan of the rules of international law, which led to the dispute at hand, justification for the grant of urgent provisional measures, and this court's jurisdiction. Now, Mr. President, I draw your attention to paragraph 5 of my statement in front of you. Mr. President, members of the court, the convention sets up, among other things, standards of conduct concerning consular relations between states, with the view to contribute to the development of friendly relations among them. The provisions under Article 36 of the Convention specifically confer rights of consular access and communication upon the sending states and their nationals, who may be arrested, detained, or put in prison in the receiving state. These provisions were interpreted by this court in the Legrande Case, Germany versus United States, and reiterated in the Vienna Case by this court, what this court said in the Legrande, and described Article 36, paragraph 1 as an interrelated regime designed to facilitate implementation of the system of consular protection, and set out again the scheme of Article 36. Mr. President, members of the court, Article 36, which has been recognized as a right of the national of a state and also the right of the state itself, is a vital safeguard that ensures a modicum of fairness in the administration of justice system of a state in its application to nationals of another state. Its provisions are sacrosanct and its violation entails serious consequences. Mr. President, members of the court, Pakistan failed to comply with all its obligations under Article 36. It denied India its right to consular access, and to its nationals, India has been seeking consular access incessantly since March 2016, when India was informed of the detention of Mr. Kulbhushan Jadhav by Pakistan. Touching upon the jurisdiction of this court in the present case, the attention is drawn to Article 36, paragraph 1 of the statute of the court, which confers upon the court the jurisdiction to decide all matters specifically provided for in treaties and conventions in force. Therefore, India relies upon the jurisdiction of this court under paragraph 1 of Article 36 of the statute of this court. India asserts that the declarations of Pakistan and India made under paragraph 2 of Article 36 of the statute have no relevance to this case. India and Pakistan are members of the United Nations and thus ipso facto parties to the statute of the International Court of Justice. They are also a party to the Vienna Convention and its optional protocol concerning compulsory settlement of disputes. Article 1 of the optional protocol provides that disputes arising out of the interpretation or application of the convention shall lie within the compulsory jurisdiction of the International Court of Justice, and may accordingly be brought before the court by an application made by any party to the dispute being a party to the present protocol. I now, Mr. President and members of the court, draw your attention to paragraph 14 of my statement. India and Pakistan are both parties to the Consular Convention and the optional protocol, and thus this dispute lies within the jurisdiction of this court and has been brought accordingly before the court by India. Now, Mr. President, I draw your kind attention to paragraph 16 of my statement. There is a bilateral agreement between India and Pakistan that seeks to supplement in some respects Article 36 of the Vienna Convention. India does not seek to rely upon this bilateral agreement. In any event, Mr. President, members of the court, the bilateral agreement is irrelevant to the present proceedings since it can only supplement the Vienna Convention. It cannot modify the Vienna Convention, nor does its text or content suggest that purpose to dilute Article 36 of the Vienna Convention. I mention this only because in one of Pakistan press communications, Pakistan alluded to this bilateral agreement. Moreover, this 2008 agreement, Mr. President, is not registered with the United Nations under Article 102 of the Charter, and therefore, under paragraph 2 of Article 102, this agreement cannot be invoked before any organ of the United Nations. Therefore, Pakistan cannot invoke this agreement before this court, undoubtedly this court being the principal judicial organ of the United Nations. Thank you, Mr. Chairman. May I now request you to invite Mr. Harish Salve, who will present India's observations in detail.
Merci. Je donne la parole à Monsieur Harish Salve, Conseil pour la République de l'Inde.
It is once again an honor for me to appear before this court to represent my country as its counsel. I express, on behalf of my country, gratitude for having fixed this hearing at such a short notice. I want to commence by assuring this court that the situation in which we find ourselves is grave, it is urgent, and it is for that reason that we have sought the indulgence of this court for a hearing for the indication of provisional measures. I shall, Mr. President and esteemed members of the court, first give you a brief overview of the facts and then address you on the following 4 issues. The jurisprudence of this court as to the principles for indication of provisional measures, the Prima Facie case as to the jurisdiction of this court to entertain India's application, the Prima Facie case of violation of the Vienna Convention on Consular Relations 1963, and finally, I would state the nature of the provisional measures that India seeks. The Republic of India, I shall be referring to it as India, has moved this application under Article 40 of the Statute of this Court, seeking release from this Court to remedy egregious violations of the Vienna Convention on Consular Relations 1963. I shall be referring to it as the Vienna Convention. It is against the Islamic Republic of Pakistan, who I shall be referring to as Pakistan. An Indian national, Mr. Kulbhushan Jadhav, whom I shall refer to as Jadhav, was allegedly arrested on the 3rd of March 2016 and has been in custody. He was tried by a military court in Pakistan and has been convicted and sentenced to death, which sentence was confirmed on 10th of April 2017. It is not in dispute that India has made innumerable requests since March 2016 for consular access. Pakistan admittedly did not provide consular access. India claims that the rights of the individual and the rights of India under Article 36 of the Vienna Convention have been violated all along from the time of the alleged arrest of Jadhav. Pakistan did not inform the consular post of India about the arrest of Jadhav at the time of the alleged arrest, and India received information of his arrest only on 25th March 2016. Despite India's requests, Pakistan has denied consular officers the right to visit Jadhav. They have refused to communicate to the consular officers the charges against Jadhav and the evidence and other material adduced against him in the so-called trial, so as to enable them to arrange for his legal representation. The denial of access to Jadhav has resulted in consular officers of India being unable to arrange for legal representation of Jadhav and to assure themselves also of his safety and his well-being in custody. In a press briefing of 17th April 2017, the Director General of Inter-Services Public Relations allegedly asserted that Jadhav was not entitled to consular access. We have a copy of the press report, which we annexed to the application as Annexure 7, which refers to the briefing but not this assertion. We now have another press report in a vernacular newspaper, Jahan, Pakistan, of 18th April 2017, which evidences this assertion. India, Mr. President and esteemed members of the court, has applied to this court for redress of its grievances relating to these violations time as the application filed by India can be adjudicated upon by this court. India has also sought indication of provisional measures that would ensure that the sentence is not executed. If the provisional measures are not granted, the application would be rendered infructuous, and it would bring about a situation that the court may find itself unable to grant effective relief as sought by India. I now address you, sir, on the principles for the grant of provisional measures. Article 41(1) of the statute of this court vests this court with the power, I quote, the power to indicate, if it considers that circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party, pending a final judgment in the case. In its judgment in a case commonly referred to as the Legrande Case, this court clarified that orders of provisional measures pursuant to Article 41 establish binding obligations. The court formulated the threshold for provisional measures in Costa Rica and Nicaragua in terms of what I call the plausibility standard. This court said that provisional measures would be granted, and I quote, if it is satisfied that the rights asserted by a party are at least plausible, end of quote. Finding that the rights claimed by Costa Rica were plausible, this court went on to observe, and I quote, whereas at this stage of the proceedings, the court cannot settle parties' claims to sovereignty over the disputed territory, and is not called upon to determine once and for all whether the rights which Costa Rica wishes to see respected exist, or whether those which Nicaragua considers itself to possess exist. Whereas for the purposes of considering the request for indication of provisional measures, the court needs only to decide whether the rights claimed by the applicant on merits and for which it is seeking protection are plausible. The standard of plausibility was reiterated in Belgium and Senegal, where the court observed that, and I quote, whereas at this stage of the proceedings, the court does not need to establish definitely the existence of the rights claimed by Belgium, or to consider Belgium's capacity to assert such rights before the court, and whereas the rights asserted by Belgium, being grounded in a possible termination of the Convention Against Torture, therefore appear to be plausible. There have been 3 instances in which this court has entertained applications arising from allegations of breach of Article 36 of the Vienna Convention. The case of Paraguay and United States of America, which is the first of the cases relating to violation of the Vienna Convention. The request of Paraguay for indication of provisional measures was decided by this court on 9th April 1998. Paraguay instituted proceedings against the United States of America on 3rd April 1998 on allegations of violations of the Vienna Convention and sought indication of provisional measures by way of an order by court that the government of the United States take measures necessary to ensure that the Paraguayan national in relation to whom proceedings were brought be not executed. This court enunciated the standards by which such a request for provisional measures would be decided. It observed that, and I quote, on a request for the indication of provisional measures, the court need not, before deciding whether or not to indicate them, finally satisfy itself that it has jurisdiction on the merits of the case. But whereas it may not indicate them unless the provisions invoked by the applicant appear prima facie to afford a basis on which the jurisdiction of the court might be founded. Unquote. This court further indicated that the purpose of the power to indicate provisional measures is, and I quote again, to preserve the respective rights of the parties pending its decision, and presupposes that irreparable prejudice shall not be caused to rights which are the subject of a dispute in judicial proceedings. Whereas it follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by the court to belong either to the applicant or to the respondent, and whereas such measures are only justified if there is urgency. Unquote. The court found that the circumstances of the case required it to indicate, as a matter of urgency, provisional measures as provided for by Article 41 of its statute. The second case, relating to violation of the Vienna Convention, was brought by Germany against the United States of America, known and cited as the Legrande Case. On 3rd March 1999, this court indicated provisional measures pursuant to an application filed by Germany. This court reiterated the principle that generally interim measures would not be ordered in the absence of, and I quote, irreparable prejudice to the rights which are the subject of the dispute, end of quote. The court held that the execution of the German national, Mr. Walter Legrande, and I quote again, would cause irreparable harm to the rights claimed by Germany in this particular case, end of quote. This court also observed that, and I quote again, measures indicated by the court for a stay of execution would necessarily be provisional in nature and would not in any way prejudge findings that the court might make on the merits, end of quote. The court indicated that the United States of America should take all measures to ensure that Mr. Walter Legrande is not executed pending the final decision in the proceedings before the court. In the third case relating to violation of the Vienna Convention was brought by Mexico against the United States of America, known as the Vienna case. Mexico sought relief in relation to 54 Mexican nationals who were on death row in the United States, and in respect of whom Mexico asserted that they were arrested, detained, tried, convicted, and sentenced to death by competent authorities of the United States in proceedings which did not comply with Article 36 of the Vienna Convention. The relief that was sought by Mexico was in the nature of restitutio in integrum. The application was filed by Mexico on 9th of January 2003 for indication of provisional measures, and the apprehension on which these measures were sought was that the three nationals could be executed within the next 6 months, and many others before the end of 2003, and one of them by 14th February 2003. This court said that it, and now I quote, must be concerned to preserve the rights which may subsequently be adjudged by the court to belong either to the applicant or to the respondent, without being obliged at this stage of the proceedings to rule on those rights. The court added that its power to indicate provisional measures is intended, and I quote again, to preserve the rights, respective rights of the parties pending its decision, and presupposes that irreparable prejudice shall not be caused to rights which are the subject of a dispute in judicial proceedings, end of quote, and that provisional measures are indicated, and I quote, pending the final decision of the court on the merits of the case, and are therefore only justified if there is urgency in the sense that the action prejudicial to the rights of either party is likely to be taken before the final decision is given. The court cited its earlier order in Finland and Denmark. This court reiterated that for indication of provisional measures, the court need not satisfy itself before deciding whether to indicate such measures, that it had jurisdiction on the merits of the case. The test applied by the court was the existence of a prima facie basis on which the jurisdiction might be founded. The court noted that the position of both parties and observed that whereas there is thus a dispute between the parties concerning the rights of Mexico and of its nationals regarding the remedies that must be provided in the event of a failure by the United States to comply with its obligations under Article 36, paragraph 1 of the Vienna Convention, whereas that dispute belongs to the merits and cannot be settled at this stage of the proceedings. End of quote. The court reiterated, and I quote again, whereas the court, when considering the request for indication of provisional measures, must be concerned to preserve the rights which may subsequently be adjudged by the court to belong either to the applicant or to the respondent, without being obliged at this stage of the proceedings to rule on those rights. End of quote. Rejecting the suggestion that there was no urgency as contended for by the United States, for no dates when execution had been set, and that there were rules and time limits governing the granting of clemency, this court found, and I quote, the fact that no such dates have been fixed in any of these cases before the court is not per se a circumstance that should preclude the court from indicating provisional measures. Even weeks, whereas the execution would cause irreparable prejudice to any rights that may subsequently be adjudged by the court to belong to Mexico, and whereas the court accordingly concludes that the circumstances require that it indicates provisional measures to preserve those rights. End of quote. In respect of the others who were on death row but not in the same position as the three persons identified in paragraph 55 quoted above, this court said that, and I quote, the court may, if appropriate, indicate provisional measures under Article 41 of the statute in respect of those individuals before it renders final judgment in this case. End of quote. And the court said that it would decide the case with expedition. This court in paragraph 55 of the Vienna used the expression, and I quote again, coming months, end of quote, which suggests to me that the court felt that an impending execution in the next 6 months, which was the period indicated by Mexico, created a situation of sufficient urgency that justifies indication of provisional measures. I now move to, sir, the urgency in the present case. It is incontrovertible that considering the state of affairs in relation to Jadhav's arrest and trial, and in the face of the communication by Pakistan to this court on 12th of May 2017, it is imperative that to prevent irreparable prejudice being caused to India and Jadhav, provisional measures would need to be indicated by the court. The communication of 12th of May purports to suggest that there are multiple legal avenues available to Jadhav, and presumably the sentence will not be executed during this period. Implicit in this is the acceptance of the reality that in case of a death sentence, the execution of the sentence cannot obviously be allowed during such time that this court is seized of an application for redress of violations of the Vienna Convention. The communication, while suggesting availability of remedies, fails to provide a clear assurance that until this court is in season of this application, the sentence will not be executed. This ambivalence is, Mr. President and esteemed members of the court, without more, a good reason for indication of provisional measures. The communication aforementioned refers to the criminal appeal. It does not clarify whether Jadhav has indeed filed such an appeal. Jadhav's mother has filed an appeal that was transmitted through diplomatic channels on 26th of April 2017. The appeal has been filed as a measure of desperation, without knowing the charges against Jadhav, the evidence against him, which has been relied upon to convict him, and without having access even to the judgment and order of conviction and sentence. Visa applications filed by his parents on 25th April 2017 are still pending. The information placed in public domain by Pakistan suggests that a court of appeal has already been constituted. It is imminent that the mother's appeal, for whatever it is worth, would be disposed of shortly. The communication of 12th of May does not indicate any timeline in relation to disposal of the appeal. The communication then goes on to mention the existence of provisions under which Jadhav may seek clemency, first from the Chief of Army Staff of Pakistan and then from the President of the Islamic Republic of Pakistan. It is not known if Jadhav will seek clemency. Even if he does, its result is, it can fairly be assumed, a foregone conclusion. It is, I submit, Mr. Chairman, Mr. President, and on esteemed members of the court, I submit with all seriousness, it is facetious on the one hand to allege in public pronouncements, including at the level of the advisor to the Prime Minister, that Jadhav has been convicted for serious offences against the state, and on the other hand to point out remedies by way of seeking clemency in its communication to this court. In its communication of 12th of May, Pakistan has not suggested that there is any inaccuracy in Annexure 6 filed by India. The statement of the advisor of the Prime Minister refers to Jadhav's right to file a mercy petition, as he calls it, but in the same breath makes observations that merit reproduction verbatim. I quote, "Let me re-emphasize 2 points. First, all political parties are unanimous that the award of the death penalty after due process and overwhelming evidence to a foreign spy who was not only carrying on subversive activities in Pakistan but actually promoting terrorism is the correct decision. Second, the whole nation is solidly united against any threat to Pakistan's security." End of quote. India has also annexed a press report of 18th April 2017, setting out an interview given by the Director General of Inter-Services Public Relations, referred to as a military spokesman. As per this press report, the military spokesman said that the case was moving towards the appeal process and would be heard by a 2-star general. And further, that he, however, did not see any chance of the verdict being overturned. The verdict is based on incontrovertible evidence, he said, and the army will fully defend it. He said, recalling the decision of the Corps Commanders Conference, that there could be no compromise on anti-state acts. India has also enclosed by way of Annexure 9 a record of press briefing by the spokesperson of the Ministry of Foreign Affairs on 20th April. Responding to a question, the spokesperson made baseless, contrived, and propaganda-driven allegations against Jadhav in India. He said Commander Jadhav, who is responsible for espionage, sabotage and terrorism in Pakistan, was tried according to the laws of the land in a fully transparent manner while preserving his right as per the Constitution of Pakistan. His sentence is based on credible specific evidence proving his involvement in espionage and terrorist activities in Pakistan, resulting in the loss of scores of precious lives of Pakistanis. End of quote. India refutes these allegations. India's position has been and continues to be that Jadhav was kidnapped from Iran and appears to have been framed based upon a confession extracted from him when he was in military custody. The allegations of Pakistan lack credibility, particularly in the absence of consular access being provided, by which India would have been able to understand the circumstances of Jadhav's presence in Pakistan, secure first-hand information about Jadhav while in military custody, and secure information about the charges against him, the evidence against him, and the order of conviction and sentence. India could also have taken measures to ensure appropriate legal representation for him. In any event, in a case of egregious violations of the Vienna Convention, the possibility of filing applications for clemency do not present a sufficient means of review and reconsideration. However, the allegations made by Pakistan establish that the suggestion in the communication of 12th of May about the availability of a remedy by way of clemency is not worthy of credence for the reason that any such process would be a chimera. Finally, it cannot be assumed that Jadhav will wait until the 60th day to seek clemency from the Chief of Army Staff, then up to the 90th day after the decision on the prior petition to seek clemency from the President of the Islamic Republic of Pakistan. It is not known whether Jadhav will at all seek clemency in the prevailing circumstances. Secondly, if he is so minded to seek clemency, it cannot be assumed that he will wait until the last day available. Thus, even if Jadhav does decide to go this route, the period could be much lesser than the 90 days plus 60 days, as is sought to be suggested in the communication. It bears emphasis that Pakistan does not suggest in the communication of 12th May that there is any judicial remedy available to Jadhav once appeal is decided. India's case and its application, as I will explain later, sir, is that throughout the period of his incarceration in Pakistan and in the course of his trial, Jadhav has been denied consular access. India seeks restitution by way of annulment of the verdict, in addition to other reliefs. After the appeal, there is no judicial remedy available for Jadhav in which he could assail the findings and the conclusions of the military court. In those circumstances, for the indication of provisional measures, what is relevant to assess the urgency is the potential lapse of time in inevitable pursuing of steps in the criminal justice process system. The availability of a right to seek a clemency is not relevant. This is particularly so in the facts and circumstances of the case, where any right to a petition for clemency is really illusory. It is therefore absolutely imperative that the order to prevent irreparable prejudice, this court would indicate provisional measures to be in place until such time as India's application can be heard and decided by this court. I now briefly address you, sir, on the Prima Facie case on the jurisdiction of this court. The standard announced by the court in relation to arriving at a prima facie satisfaction as to the existence of jurisdiction at the stage of deciding upon a request for indication of provisional measures is that the court, and I quote now, need not finally satisfy itself before deciding whether or not to indicate such measures, that it has jurisdiction on the merits of the case. Yet it may not indicate them unless the provisions invoked by the applicant appear prima facie to afford the basis on which the jurisdiction is founded. End of quote. The principles are succinctly summarized in the commentary in the leading treatise on the Statute of International Court of Justice, edited by Zimmerman. It states, and I quote, "Since the Icelandic fisheries cases, the court's jurisprudence has been constant in requiring that the instrument invoked by the parties conferring jurisdiction appears prima facie to afford a possible basis on which the jurisdiction of the court might be founded." End of quote. The application filed by India is based on Article 36 of the Vienna Convention. India bases its assertion of existence of jurisdiction on Article 1 of the optional protocol concerning the compulsory settlement of disputes 1963, which accompanies the Vienna Convention. I shall refer to it, sir, as the optional protocol. Article 1 of the optional protocol reads thus, and I quote, "Disputes arising out of the interpretation or application of the Convention shall lie within the compulsory jurisdiction of the International Court of Justice and may accordingly be brought before the court by an application made by any party to the dispute being a party to the present protocol." The language of Article 1 of the optional protocol admits of no ambiguity. The binary requirements for the existence of jurisdiction are A, the existence of disputes that arise out of the interpretation or the application of the Convention, and B, the party that brings an application before the court raising such a dispute should be a party to the optional protocol. Indisputably, on 8 May 2017, when India presented its application, India and Pakistan were and continue to be parties to the Vienna Convention on Consular Relations, as well as to the optional protocol. On 12th of May 2017, communication by Pakistan does not suggest to the contrary. India asserts in its application that Pakistan has not provided consular access to Jadhav all along, from the time of his alleged arrest until the present, despite repeated entreaties by India. Pakistan offered no explanation in its exchanges with India as to the reason why it has not provided consular access, whatever may be the reasons that Pakistan may proffer in defense of its acts and omissions. Disputes have arisen between India and Pakistan when India asserts, and Pakistan presumably would deny, violations of the Vienna Convention. These disputes would relate, if not entirely, substantially, to the interpretation of the Vienna Convention and to its application to the facts of the case. India asserts that the Vienna Convention admits of no exceptions. India has not been given a copy of the charges or the verdict and is therefore unable to comment on the allegations levelled against Jadhav. From the information in public domain, such as the public statements in Annexure 6 and Annexure 7 to India's application, it appears that the charges were grave and suggestive of acts of terrorism. India refutes these charges, but the merits of the case, Mr. President and esteemed members of the court, I remind myself, are not material for these proceedings. What is relevant as a principle of law is that need for a wholesome compliance with the procedural safeguards is greater when the charges are serious and the sanction upon conviction is as severe as a capital punishment. As this court said in Paraguay and United States of America, and I quote, where the issues before the court in this case do not concern the entitlement of the federal states within the United States to resort to death penalty for the most heinous crimes. And whereas the function of the court is to resolve international disputes between states, inter alia, when they arise out of the interpretation or application of international conventions, and not to act as a court of criminal appeal. End of quote. This principle was also reiterated in Vienna and Legrande. It bears repetition that where the national of another state is accused of acts of terrorism, and which, if established, carry the sanction of capital punishment, and the trial is by a military court, the need for consular access and the opportunity to arrange for legal representation in the course of the trial, as covenanted in the Vienna Convention, is all the more greater. An Indian national was in military custody. He was made to confess, and then he was tried for offences and awarded death penalty. The prejudice caused by egregious breach of the Vienna Convention assurances provided for in Article 36 is writ large and does not merit any further elaboration. India asserts that the breach of the Vienna Convention and the facts of the present case is fatal to the trial of Jadhav. In its communication of 12th of May, Pakistan states that it, and I quote, rejects the contents of the request and of the application as providing any basis for this court to exercise jurisdiction, whether by way of preliminary measures, relief, or otherwise. End of quote. India bases its application on the jurisdiction of the court conferred by Article 36, paragraph 1 of the statute of the court, and Article 1 of the optional protocol concerning the compulsory settlement of disputes 1963. The binary conditions by the optional protocol are satisfied. That being so, this court would have jurisdiction under Article 36(1) of the statute, paragraph 1 of the statute of this court. India has thus provided, I submit, sufficient basis for this court to come to the conclusion, definitely prima facie, that it has jurisdiction. I now move, sir, to addressing you on the jurisdiction of this court under Article 36, paragraph 1. The compulsory jurisdiction of this court under Article 36, paragraph 1 has three dimensions. Jurisdiction exists, A, in respect of all cases which parties refer to it, B, in respect of all matters specially provided for in the Charter of the United Nations, or C, in respect of all matters specially provided for in treaties and conventions in force. The optional protocol specially provides for resolution of disputes relating to the Vienna Convention its language is mandatory. It provides that all disputes arising out of the interpretation or application of the Convention, and I quote, shall lie within the compulsory jurisdiction of the International Court of Justice. End of quote. Article 36, paragraph 2 of the statute deals with a declaration by party states of the recognition, and I quote, as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation. End of quote. India does not seek to assert jurisdiction for its application. In paragraph 2 of Article 36 of the statute, any reservations made in the declaration made under Article 36, paragraph 2 are irrelevant for the present case. The construction of Article 36 is no longer res integra. The fact that this court may have more than one jurisdictional basis is now well recognized, and where there is a multiplicity of agreements, it evidences that, and I quote, contracting parties intended to open up new ways of access to the court rather than to close old ways or allow them to cancel each other. End of quote. The general principle where the court has jurisdiction based on both optional declarations and compulsory jurisdiction clauses in treaties is that each title is autonomous and ranks equally with the others. The commentary in Robert Kolb's book is illuminating. It says, and I quote, where there are several concurrent titles of jurisdiction, they do not cramp or limit each other's effects. On the contrary, they complement and reinforce each other on a cumulative basis. End of quote. It says that the reservations in one title of jurisdiction cannot be transposed into the other. The argument that, and I quote, the title of jurisdiction resulting from optional declarations has a higher value in the hierarchy than one deriving from a treaty must be rejected. End of quote. The commentary tells us that titles of jurisdiction remain in existence until either modified or terminated, and it cannot be argued that, and I quote, a more restrictive subsequent optional declaration is evidence of the state's will to submit to the court's jurisdiction in a more limited way, so that a prior and a more widely worded compromissory clause must be considered to have undergone a kind of derogation, or vice versa. It is for the parties themselves to choose the titles of jurisdiction they intend to rely on. End of quotation. Mr. President and esteemed members of the court, India relies on the Vienna Convention, the optional protocol, and Article 36, paragraph 1. The jurisprudence of this court also concludes this issue. In the Electricity Company of Sofia and Bulgaria case, the Belgian government relied on declarations of Belgium and Bulgaria accepting the compulsory jurisdiction of the court, and also on the treaties of conciliation, arbitration and judicial settlement entered into between Belgium and Bulgaria on 23 June 1931. The Bulgarian government challenged the jurisdiction of the court. It was in this case that the court held that, and I quote, multiplicity of agreements concluded accepting compulsory jurisdiction as evidence that contracting parties intended to open up new ways to access the court rather than to close old ways or allow them to cancel each other out, with the ultimate result that no jurisdiction would remain. End of quote. In Nicaragua and Honduras, Nicaragua instituted proceedings in respect of a dispute concerning the alleged activities of armed bands said to be operating from Honduras. It founded the jurisdiction of the court on the American Treaty on Pacific Settlement, known as the Pact of Bogota, and also the declarations of the two parties. Honduras resisted jurisdiction on the ground that the dispute was excluded by terms of the Honduran Declaration of 22nd May 1986, and claimed that the declaration would apply to the Pact of Bogota. Honduras relied on the language of Article 31 of the Pact, which opened with the words, and I quote because they are important, in conformity with Article 36, paragraph 2 of the Statute of the International Court of Justice, unquote. Mr. President and esteemed members of the Court, you will find no such words are to be found in the optional protocol. In the Honduras case, on the basis of those words, Honduras argued that the declaration made by it under Article 36, paragraph 2 of the statute delineated the extent of jurisdiction even under Article 31 of the Pact. This argument was rejected by the court, finding the language of Article 31 made it clear that it did not subject itself to the making of any new declarations to be deposited under Article 36, paragraphs 2 and 4 of the statute. The court observed in paragraph 33, turning to the Honduran interpretation, and I quote, "The court may observe at the outset that two possible readings of the relationship between Article 31 of the statute, 31 and of the statute have been proposed by the parties. The article has been seen either as a treaty provision conferring jurisdiction upon the court in accordance with Article 36, paragraph 1 of the statute, or as a collective declaration of acceptance of compulsory jurisdiction under paragraph 2 of that same article." End of quote. In that case, the argument by Honduras based on Article 31 of the Pact, which expressly referred to Article 36, paragraph 2. Significantly, the court recognized that there could be a treaty provision in which event it confers jurisdiction upon the court in accordance with Article 36, paragraph 1 of the statute also. However, while dealing with Article 32, the court noticed that this article referred to the jurisdiction of this court under Article 36, paragraph 1 of the statute. This issue arose once again in Nicaragua and Colombia. The court upheld a challenge to its jurisdiction under the Pact of Bogota in respect of disputes settled by the Pact. Nicaragua sought to sustain its complaint in relation to these very disputes under Article 36, paragraph 2 of the statute. This was rejected by the court, and a challenge to its jurisdiction upheld on the ground that to the extent the territories were settled under the Pact, there was no legal dispute between the parties. Judge Abraham, as the Honorable President then was, in a separate opinion, expressed his view that he found the argument of exclusivity of the Pact convincing. The judgment explained that the observation in the judgment of Electricity Company of Sofia and Bulgaria were undoubtedly correct as a general rule, but recognized that the general rule in the words of the judgment, and I quote, fails to take into account any of the distinctive characteristics of the Pact of Bogota, end of quote. Thus, there may be distinctive pacts, and those would be governed by their own terms, and where they recognize the jurisdiction of this court as a mechanism for dispute resolution, this court would have the jurisdiction to entertain applications in relation to all such disputes as fall within the pacts. And this jurisdiction, Mr. President and esteemed members of the court, I submit, would be found in Article 36, paragraph 1 of the statute. In the ICAO Council case, India moved an application relying on Article 84 of the Convention on International Civil Aviation and Article 2 of the International Air Services Transit Agreement. The jurisdictional clauses of the treaties allowed an appeal to the court from a decision of the Council. One of the defenses raised by Pakistan was that the effect of one of India's reservations to her acceptance of the court's compulsory jurisdiction under Article 36, paragraph 2, rendered this court incompetent to entertain this appeal. The court rejected the objection, holding that the various objections made to the competence of the court cannot be sustained, whether they are based on an alleged inapplicability of the treaties as such or of their jurisdictional clauses. Since, therefore, the court is invested with jurisdiction under those clauses, and in consequence, under Article 36, paragraph 1, and under Article 37 of its statute, it becomes irrelevant to consider objections to other possible bases of jurisdiction. The jurisdiction of the court in 3 cases cited earlier relating to violations of the Vienna Convention were also entertained as disputes in the jurisdiction in relation to which was founded in Article 36, paragraph 1. In Legrande, the court proceeded on the footing that the application filed by the Federal Republic of Germany for the violation of the Vienna Convention was based on the jurisdiction of the court under Article 36, para 1 of the statute, read with Article 1 of the optional protocol. In fact, this position was not challenged by America. In Vienna, this court noted that Mexico asserted jurisdiction of the court under Article 36, paragraph 1 of the statute and Article 1 of the optional protocol. The agreement on consular access between India and Pakistan is irrelevant for the present proceedings. Mr. President and esteemed members of the court, I say it is irrelevant for 3 reasons. Firstly, India does not rely upon the bilateral agreement on consular access, which it entered into with Pakistan in May 2008. The agreement, as recognized by Article 73 of the Vienna Convention, was with the object of, and I quote the language of Article 70 of the agreement itself, with the object of furthering the objective of humane treatment of nationals of either country arrested, detained, or imprisoned in the other country. End of quote. Some of the provisions of this agreement reinforce obligations of the Vienna Convention. These are the obligations to immediately notify, and I quote, any arrest, detention, or imprisonment of any person of the other country, end of quote, to the High Commission, and, I quote again, to expeditiously inform the other of the sentences awarded to the convicted nationals of the other country, end of quote. India does not rely and does not need to rely on this agreement. It bases its claims solely upon the Vienna Convention. India's claim in its application is deho this bilateral agreement. Article 102, Subarticle 2 of the United Nations Charter 1945 proscribes invocation of any agreement unless it is registered. This agreement is admittedly not registered. Article 73 of the Vienna Convention recognizes that the Vienna Convention does not affect other international agreements in force. It also, however, expressly does not, and I quote, preclude states from concluding international agreements confirming or supplementing or extending or amplifying the provisions thereof. End of quote. Article 41 of the Vienna Convention on the Law of Treaties recognizes and expostulates the established principle of international law that 2 or more parties to a multilateral treaty may conclude an agreement to modify the treaty between themselves if the possibility of such a modification is provided for by the treaty, or the modification in question is not prohibited by the treaty and does not relate to a provision the derogation from which is incompatible with the effective execution of the object and purpose of the treaty as a whole. Mr. President and esteemed members of the court, I submit that Article 73 of the Vienna Convention recognizes that there is scope for parties to supplement and amplify the provisions of the Vienna Convention. It does not, certainly does not, countenance a dilution of the principles embodied in the Vienna Convention. But I repeat, we do not rely on this bilateral agreement. I now move on to the next segment of my submission, which is a prima facie case of violation of the Vienna Convention. The facts set out in the application, and which are supported by the exchanges between India and Pakistan, establish more than just a prima facie violation of the Vienna Convention. On 25th March 2016, India was informed that Jadhav was allegedly arrested on 3rd March when the Foreign Secretary of Pakistan raised the matter with the Indian High Commissioner in Islamabad. On that very day, India sought consular access to Jadhav. On obtaining no response from Pakistan, India sent a reminder on 30th March, reiterating its request for consular access. Innumerable requests through formal notes verbal and verbal démarches were made to Pakistan. between March 16 and April 17 for consular access to Jadhav. The requests, however, elicited no response from Pakistan. On 23rd January 17, which was almost a year after India's first request for consular access, India received from Pakistan a request for assistance in investigation of what was described as, and I quote, FIR number 6 of 2016, end of quote. Under the Pakistan Code of Criminal Procedure, the expression FIR is an acronym for First Information Report, which is registered after the police first gets information as to the commission of a crime. This was registered against the Indian national, apparently on 8th April 2016. What is significant is that the letter acknowledged that this FIR had been registered against an Indian national. The nationality of Jadhav has never been in doubt. Thus, the international obligation to allow consular access under Article 36 of the Vienna Convention has admittedly been breached by Pakistan. It is obvious that even the right of Jadhav to seek and obtain consular access has been breached by Pakistan. On 3rd February 17, India protested through a démarche against the continued denial of consular access to Jadhav. The letter from Pakistan seeking assistance also established that there was a purported confession by him, which was the basis, or at least a significant part, of the case against him. India has raised concerns as to his safety, pointing out that, and I quote, questions about his treatment in Pakistan's custody continue to mount, given especially his coerced purported confession and the circumstances of his presence in Pakistan remain unexplained, end of quote. On March 3rd, 2017, India reminded Pakistan of the various requests. India received another note, verbal, on March 21st from Pakistan. In this, Pakistan stated, and I quote, that the case for consular access to the Indian national shall be considered in the light of Indian side's response to Pakistan's request for assistance in investigation process and early dispensation of justice. End of quote.